Good morning, everyone, and welcome to our Making Your Intellectual Property Work for You session. My name is Wayne Bryant. I am a Senior Innovation Manager at an organisation called We Are Umi, delivering this under a project called Pathways to Innovation Gateshead, funded through UK Shared Prosperity Funding on behalf of Gateshead Council. So welcome, everyone. I will say throughout the session today, please do come to me with questions. This will be a live Q&A at the bottom there for any questions. Speak for 2 hours without getting questions. So please do throw your questions at me in the bottom, and I'll deal with them as and when we can. We will take a brief break in the middle somewhere, and we'll just see how we get on. So as I say, just to introduce myself, my name is Wayne Bryant. I'm a Senior Innovation Manager at We Are Umi. I've been in the innovation space for, I would say, 12 years now. I think it's probably about my 12th year just this month. In that time, I've had varying roles. So I started out working with NHS trusts, writing intellectual property strategies and innovation strategies, and doing technology transfer within the NHS. So that would be protecting intellectual property within the NHS, using it, protecting NHS research, and trading it with industry to bring new med tech products, new medical diagnostic tools, and various things to market. And in that time, I did that for about 4.5 years, and took about 21 licenses, NHS licenses, licensed to industry to bring products to market. So quite a success. Delivered some time doing technology transfer for European research consortiums into fusion energy. So taking technologies out of the tokamak, which is a fusion generator. There's only a number of them in the world. So taking the technologies out of the tokamak, out of the fusion generator, and putting them into other industries, automotive, health and med tech, various different industries. Supported over probably 350 Northeast businesses in the region on IP strategy and growth in relation to IP, largely digital. So just come off the back of delivering a big digital program for the Northeast Combined Authority. And my background is I was trained to do this 12 years ago by an organisation called Praxis. So trained in the fundamentals of and the complexities of managing intellectual property in these complex situations. So that's my background. That's why I talk about this. Okay. So let's start simple. What is intellectual property? So intellectual property refers to the creations of the mind, inventions, literary and artistic works, and symbols and names of images used in commerce. Now, when I talk about intellectual property, I have quite a passion, especially working with small to medium enterprises in the Northeast. I have quite a passion to make sure that we aren't spending money that we don't need to be spending, and that we're making informed decisions on intellectual property that benefit the business. And I think that's what today's about. It's about talking about how can you make your IP work for you? How do you make money off intellectual property? You know, we'll talk about patents and trademarks and such forth, but how do you protect it? Yes, and we'll talk about protecting it. We'll talk about how you protect it, but then once you've protected it, once you've got your patent certificate, or once you've got your patent pending number, once you've got your trademark, what does that mean for you? What does that mean for you, and how can you make money off that? It's an intangible asset for you to make money and help you grow your business. So I think with that in mind, the first thing I'm happy to say, and I say quite often, is if IP doesn't deliver a return on investment, or it doesn't deliver you a clear commercial advantage amongst your competitors, then you need to make some serious considerations whether to invest in it in the first place. So yeah, absolutely, that's where I stand on that. So but we'll talk about that. So as I say, I'm not here to tell people to invest in intellectual property. And people will quite often say to me, Wayne, we tried the intellectual property route. We invested a lot of money and it didn't pay off. I want people making more informed decisions on that. And that's what we'll be talking about today, how you can do that and how you can get better informed. So we will start with the basics. So different types of intellectual property. The big one. So this is recognized forms of identifying what intellectual property you have. A lot of them registered, so registered with the UK Intellectual Property Office or intellectual property offices across the world if you so wish to exploit other markets. But we'll just talk briefly about what each one is and what they do. So your patents is sort of the bells and whistles of intellectual property. It's the most complex form of intellectual property protection, and it's an exclusive right for an invention. So it protects the way something works and the way something functions, which is it can protect products or processes. In general, it needs to be innovative, a new way of doing something, offer a new technical solution to a problem. To get a patent, technical information about the invention must be disclosed to the public in a patent application. So patents, probably what most people think of when they talk about intellectual property, and when they talk about it, they probably talk about it in terms of wanting to keep something a secret. So they come up with an idea, they come up with an invention, and they go, I need to make sure that this is protected as a secret, and the patent is a way to do that. I guess for me, I would probably be being conservative by saying that in filing a patent and using a patent attorney to file a patent, you're probably looking at, to get to publication, 3 to 5 years and £25,000 upwards coming out of your bank to do that. So because that's quite a long-term investment, and it's quite a large investment for a small to medium enterprise in the Northeast region, that's why it really is a decision that needs thinking about. It's not just about reacting to, I've had an idea. The next thing is to go and patent it. What am I going to do with the idea? How far can I take it in the market? Am I going to be the commercial vehicle myself? Am I going to manufacture? Am I going to, am I going to create a manufacturing plant and develop this invention myself? Or am I just going to protect it with the patent and then license the patent or sell the patent onto someone else to do the rest of the work? And these are things you need to think about. So patents, as I say, I do always advise, yes, absolutely use a patent attorney to draft your patents. I get a lot of people asking questions about drafting patents. I don't touch that area of intellectual property. I think it's a very bespoke and it's a very niche skill set being able to draft a patent. And yes, some people go off and some people go off and do draft patents themselves and successfully. But a lot of the time, I recommend that you use a patent attorney. They do a lot of liaising with the intellectual property office to get your patent to where they feel it needs to be to get publication of the patent. We can talk about things like getting publication of the patent, but sometimes actually you want it to be within your strategy to you don't have to publish your patent. Maybe you get a patent pending, and maybe you do a lot of your trading and a lot of your business growth in a time where the patent hasn't yet been published. And actually, after the 3 to 5 year period that you've spent getting it ready for publication, at that point you might go, actually, there's no value in this actually going to publication. I don't really need to anymore. And that's a strategy that we've seen become more, certainly in the tech world. So in the tech and digital world, your tech and digital world, it moves so fast. It's an industry that moves so fast and changes so fast that what are the chances that there's commercial value in something that has commercial value today? Will it have commercial value in 3 to 5 years' time? And a lot of time, the answer is no. Technology has changed so much and grown so much and pivoted and moved on that, so these are things that you need to think about. I don't want to dwell on it, we'll go into it more later, but we need to think of patenting as a strategy rather than trying to attain a certificate to say I've got a patent. Yes, that's a nice thing to have. Yes, it has value, but like I say, some industries move quicker than the process does. So we need to think about whether we're making the right decisions in that. A second form of intellectual property, another form of registered intellectual property, so registered with the Intellectual Property Office, is trademarks. Trademark refers to a recognizable insignia, phrase, word, or symbol that denotes a specific product and legally differentiates it from all other products of its kind. So trademark is about your brand. It's about your product brand, and often you will protect your trademark early on, register your trademark, and then it will only become valuable in terms of an asset, an IP asset, as you grow your brand. So when you first trademark when you first file your trademark to protect your logo and protect the name of your brand or the name of your product, you might go, well, why am I doing this? But it's about aligning it with your marketing strategy and then adding value to the brand. And once the value is added to the brand, then that's where you need it protected. So you do it at the outset, and it sort of gains value down the line. There is such thing as unregistered trademarks, which do what they say on the tin. It means that someone hasn't gone to the Intellectual Property Office to register their trademark. It's best to register it and have that sort of flag in the sand with the Intellectual Property Office. Trademarks you can register them yourself. You can use a trademark attorney. There is 45 different classes of trademark classification. So when you file your trademark, you have to choose between 45 different classifications. You might enter into 2 or 3, you might enter into 5 or 6, you might just enter into 1. And that's what goods or services you're providing and what markets you're selling into. So getting that decision right and protecting in the right areas is really important. But that stuff, I've done that work with clients. I can do that work. So, if you want support looking at that, do reach out. But trademarks, largely protecting, aligning with your brand strategy, which we'll talk about later. And it's not getting one or the other. You're not going, I've got a patent, so I don't need a trademark. You're talking about building an IP portfolio, an intellectual property portfolio of different types of intellectual property to add value to your business. And then if you want to sell your business or you want to license your product, which we'll talk more about later, you have this value that you can go, well, what are you giving me? What are you giving me for what I'm paying for? And you go, well, I'm giving you rights to this trademark. I'm giving you rights to this patent. I'm giving you rights to this body of copyright. And that all comes together in your IP portfolio. Okay. Copyright. So copyright is not a right that's registered with the Intellectual Property Office. So essentially, the second you create copyright, it's assigned to you automatically if you are the creator. So it's about being the original creator, original literary, dramatic, musical, artistic works, illustrations of photography, and the strength in it is asserting your copyright. So you will have seen, everyone I'm sure in the room will have seen that you'll pick something up and it will have a copyright stamp, a copyright assertion on the bottom saying copyright company name 2023, and that just says we created this in 2023. We recognise that we own it as copyright. And hopefully that drives people to speak to them if they want to use that copyright in a certain way, and then that can open up the sort of terms of negotiation of how that copyright is used or can be used by other parties. So no central registration with the Intellectual Property Office. A lot of third-party companies out there who will tell you that they can protect your or timestamp your copyright materials. That's okay. It just doesn't necessarily do anything because you own that copyright the second you create it, and you can assert that yourself. So any questions about that, again, though, do come and speak to me. Okay, we'll talk more about that later on. Design rights. So design rights are kind of, for me, the younger sibling of patents. A lot of patents protected will be protected by design rights as well. So you get registered design. So you do register these with the UK Intellectual Property Office through the government website, just like trademarks and just like patents are registered through the UK Intellectual Property Office. And they protect the visual appearance. So you might have, for example, without using a sort of cliche examples, you have an iPhone. An iPhone will have a number of patents inside it that dictate how it works and make it work. And if you took one of them out, you could then not create an iPhone. So that's the value in the patent. And then the outside, the thing that you're looking at, the aesthetics of it, that's all protected by various design rights. So someone can't put what they want inside and then just make something that looks the same and have people buy it, because then they'll be infringing the design rights. So design rights, all about technical drawings, all about high quality drawings and registering them with the Intellectual Property Office. And again, considering that as a building your portfolio, it's not just this is protected by design, so it's not protected by patents, or this is protected by trademarks, so it's not protected by designs. It's about what different bits of intellectual property do I need to add value to my proposition, to add value to my business? What intangible assets can I help to add value? And finally, trade secrets. And trade secrets do exactly what they say on the tin. Trade secrets are probably lesser spoke about as a form of intellectual property, but like I say, they do exactly what they say on the tin. People quite often talk about them in terms of being an alternative to filing a patent, because they say, oh, well, it doesn't cost anything. Patents cost all this money. Patents take all this time. If I keep a trade secret, I can save a lot of money, and that's it's a strategy, and strategized properly. It's a perfectly viable strategy, but I think it's not just saying you're doing it and then going off and doing it. The weakness in a trade secret is it's a secret, and once the cat's out the bag, you ain't getting it back in again. So people have trade secret strategies. I would always say this: there's probably a lot of people perceive that they will lose their intellectual property to competitors trying to find out what they're doing. It's more likely you will lose your intellectual property from employees leaving your business and moving on to competitors. That's where you're going to lose your intellectual property. And your trade secret strategy, if you have trade secrets within the organization, your trade secret strategy needs to do as much as they can to negate that happening. So when people leave your business, and yes, they will ultimately go on to work for competitors. Yes, you might have seen non-competitor clauses in work contracts and such forth like that. But you can't leave a job and then completely switch up what you do as what industry you work in. You're experienced in an industry, and ultimately you may well go and work for a competitor. Trade secret strategies are about keeping things secret, but formally keeping things secret. And trade secret strategies is something I've done a lot of work on. So if you think that's the way you want to go, but you want a strategy around that, that's something we can help with as well. Okay, let's move on to the next. So who owns intellectual property? So the owner is normally the inventor, the designer, the creator, so the person who creates it. So when you create this, it's your intellectual property. If you file a patent, if you file a trademark, that is the intellectual property office, the UK intellectual property office, or from another country, if you protect elsewhere, recognizing that that's your intellectual property. But ultimately, when you create it, you should own that intellectual property, and that's how the world works. You create it, it's your intellectual property. Ownership can often automatically get transferred to an employer when the intellectual property is created within the first owner's job role. So if you're running a business and you are employing people, it's belt and braces and best practice to have a clause within their contract to say anything you create within your role, the intellectual property automatically reverts to the company who you work for, the person who pays your wages. It is kind of an unspoken rule, so people have businesses successfully laid claim on intellectual property without that clause being in place. But why would you not put it in place? It's a simple clause in a contract to tighten up your position. The example I always use, and I use this from my National Health Service days, is it tends to come down to if there was no clause in there's no clause in the contract, it would come down to, is what you created part of your role? Was it part of your role to innovate? Was it part of your role to do research development? Or was it knowledge that you gained within your role that allowed you to create that? And the example I always use is if you're a surgeon in doing surgery day in, day out, and you create a new set of forceps, then you know how to do that because you're a surgeon. You've created innovative forceps based on what you've learned by working for your employer, and the intellectual property would likely revert to your employer. If the cleaner who comes in and cleans the surgical room creates the same forceps, they might have an argument that, well, it's not really my job to create innovative forceps, and therefore it's not within my job role, and I might keep the intellectual property. But from a business point of view, I think it's belt and braces stuff and making sure that you strengthen your position as much as you can. So as I say there, ownership often automatically gets transferred to an employer when the intellectual property is created within the first owner's job role, but not always. It is worth having an IP management clause in employees' contracts. IP agreements transferring ownership of IP to the correct party are very important. So there's a lot of intellectual property floating around, shall we say, in the world, and it's created. So once someone creates something, it's intellectual property, and they think they own it, or they don't think they own it. Let's pull an example on that one. So I work with a lot of companies undertaking digital development projects and using digital developers to build applications for them, build platforms for them. That developer may go, I don't want that intellectual property. That's my client. And the client will go, oh yes. I sat in a meeting with the digital developer, and they said, yes, all the intellectual property sits with you. And everyone agrees that the customer owns the intellectual property. And then you look at the agreements that were signed. So you look at the contractual agreements, and there's no movement of that intellectual property. So it doesn't say in the agreement that the intellectual property that was created by the developer, remember, it was created by them, so they own it. It doesn't say that it's moved and now is with the customer who paid for the project. So that's really important to have that written clause where if someone said, can you show me when that IP moved in legal terms, you can go, look, here's the clause where it happened. You're not saying, well, it was disclosed in a meeting, or it was said when we first spoke to them. You're saying, here's the clause that says, when I undertook this project and paid for it, I took all the IP at the other end. And as a business going through an innovation project, you want to be thinking constantly about retaining that intellectual property. How do I keep that intellectual property within the business? I may need to use external developers. I may need to use marketing people. I may need to use designers. I may need to use all these people, and that's fine. It's not conceivable that you employ them all in your business. You may use third parties. But when doing that, always thinking, is this intellectual property that's being created for the terms of the project coming back into the company, and do we own it all? I've worked on projects, NHS projects that have, medical diagnostic tools that have stemmed from years of university research, and someone starts off, doing a PhD, and they start doing this research, and then they move into working in a trust, and then this happens, that happens, and you might be looking at 10, 15 years worth of development, and then you sit down and you go, do you own all the intellectual property? And they go, oh yeah, all of it. And I go, shall we track back then 15 years and look at every point in which it's left the business? And it turns out that they're misrepresenting. They don't own all the intellectual property. Various things have happened, and you kind of have to go through you have to backtrack and see if you can get hold of that intellectual property. Otherwise, you're misrepresenting. And if you're looking for investment, having that sort of clean map or tree of intellectual property ownership is really important to investors. So, ultimately is important. You don't want to misrepresent. You don't want to infringe someone else's intellectual property. So getting it right is really important. And lastly on this, never assume intellectual property rights have been properly transferred until you see it in writing. So I probably talked a lot about that, or a bit much about that, but I can't stress it enough. You will find that everyone has, good intentions most of the time. And they all wanted to sit in a certain place, the intellectual property to sit with someone in particular. But ultimately, if the contracts don't say it does, then there's an argument that it doesn't. And if when that comes to light, the project is making money and you started making money off your innovation, then the person who developed it for you on your behalf, who you paid, might not be so open to transferring that intellectual property to you automatically, because they might go, well, I want a hand in this. It's making a lot of money now. So I don't want to touch too much on them agreements, but I will briefly touch on them. So you're using a third party to do some development work for your project, some design work, whatever it is. You want to see a clause in there as an SME. You probably want to see a clause that says, upon payment of the agreed project, or something along the lines of, upon payment of the agreed project, all intellectual property reverts to the customer who paid for it. Okay, that means once you pay, money goes one way, intellectual property goes the other way. Nice legal transaction, everyone's happy, and the intellectual property is where it does. Another clause that you see is, upon completion of the project, we will grant you a royalty-free license to exploit the intellectual property that's being created. That works in certain situations. It rarely works for an SME undertaking an innovation project. So if you're in the room when you're an SME undertaking an innovation project, you want to be looking for that retaining the IP and fully owning it. If you think there's a situation where you want a royalty-free license to exploit, or you think there's a relevant situation, or you just want to discuss what that looks like, come and have a chat with us. Absolutely no problem at all. So we're talking about innovation. It's an innovation program that gets the pathways to innovation. When we talk about innovation and bringing innovative products to market, we see a lot of people. I talk to a lot of companies, and a lot of them are innovating. I'm delivering innovation projects, and I'm supporting on innovation projects. So I will ask the question of what's innovative about this, and the way of proving the ultimate way of proving something is innovative is the use of intellectual property. So if you've got a patent on something, that means that people have gone away and researched and confirmed its novelty and its innovative approach. So you've got to pretty much sign off there. Quite often people say, I don't have any IP, it's expensive and pointless. So we can see straight away it's got a little red flag next to it for obvious reasons. It's a red flag, especially when I'm talking to clients. One, it's a very sweeping statement. We don't have any IP. Of course you have IP. Everything you create within the business that you created yourself is your IP. It's expensive and pointless. So this second bit is probably where the client's talking about the cost of paying a patent attorney to draft a patent, or the cost of filing a trademark with the Intellectual Property Office. And they're saying it's pointless. Now, further down this presentation, we'll talk about your intellectual property strategy aligning with your business plan or your business growth strategy, and you'll see why that's not pointless. If you make an informed decision, if you learn about, if you align it with your business plan and it still says it's expensive and pointless, then it might be expensive and pointless. But if you haven't considered all the different things that we'll talk about down the line, then it's a very sweeping statement to say it's expensive and pointless. It's an investment, and with that, you need to think about return on investment. The amount of times people go, "Oh, I'm filing a patent," I go, "Well, when do you expect to get a return on investment on that?" Particularly products that are low cost and per unit, low cost per unit. They go, "Oh, we're going to sell this on I don't know, Amazon for £1.50 a unit," and you go, "Well, you'll take a long time to get your £25,000 back for filing the patent. Does the patent do everything you need to do? Does it protect you? Does it stop people copying it?" A lot of questions. So if you're going to pay for it, make sure it's worth it. But the other side of the coin is, don't just say it's expensive and pointless, because that's not true. So when you're thinking about this, you're thinking, what tangible and intangible value do I have in my business? If the answer is nothing, there's no value in the business, then the business is ultimately not worth anything, and you're going to struggle to make business out of it. So what assets do I have that someone else cannot quickly or easily attain or build themselves? This is ultimately, I think this is the key to intellectual property. You go, the intellectual property stops someone copying it, stops someone building it themselves. Another thing that stops people building something themselves is time. So if you spent 20 years building something and someone goes, "Oh, well, I can just build that myself," you might probably can just build it yourself. But with the information you currently have, I went on that journey, started 20 years ago. So you'll take 20 years and I'm going to be exploiting the market for that 20 years. So, time put into something is value added as well. Intellectual property has got a flag in the sand to say, also, you can't do that. You can't do that because you'd be infringing my rights and all the hard work that I've done. What information do I have that is commercially sensitive? We will talk about confidentiality agreements and non-disclosure agreements as well today, briefly down the line. But be thinking about this. So what assets do I have that someone else cannot quickly or easily attain or build themselves? What information do I have that is commercially sensitive? And what do I have any intellectual property? Yes, you do. But what intellectual property do I have? So looking at the first two questions, get yourself thinking about what intellectual property you have within your business and what value that adds to your offering and what you can offer to people and how you want to grow your business. Okay. So be aware, this is a big one. So we talked about that intellectual property portfolio and growing that portfolio of what you have to build an intellectual property portfolio. Be aware that an undue focus on one type of intellectual property protection, such as patents, might mask the fact that protection of trademarks or the use of effective contracts to preserve trade secrets might be a better way to advance the values of the business. So that's IP strategy. IP strategy aligning with business strategy, very important. But having that IP strategy and going, look, especially let's take an example. So you have something that you've decided not to patent, and down the line you go, right, I'm going to be the commercial driver who takes this to market. I can't bootstrap this. I can't pay for this business myself. I'm going to look for external investment. And you go through all the process of and stuff that we do. We work with a lot of clients on, getting your business plan right, creating your pitch deck, pitch practice pitching to investors. And that investor can ask you anything within their rights to turn around and ask is this protected? Am I investing in something that's got protection? And you might go, well, what you can't do is go, no, because it's expensive and pointless. That's not going to get you anywhere. You're not going to get that investment. I'm pretty confident saying that you're not going to, if that's your answer to that question, you're not going to get that investment. So saying, we reviewed the position regularly, considering filing a patent, but actually we're quite comfortable that we have used trade secrets and our trade secret strategy as a better way to keeping the value within this business and make it, make it a good investable proposition. And how you came to that decision. And then also we also file a trademark and protected these design rights. So patent isn't the only thing. Yes, someone might go, I would want to see a patent on this. When that happens, when you're talking to investors, £25,000 for a patent might seem like a big investment for the business. If you're talking to an investor who's going, I'm going to give you £500,000, but I'd like to see a patent on it, you speculate to accumulate. We could get this money, we could get £500,000, but we have to pay £25,000 up front. We need to start thinking about how we can do that. But absolutely, be open-minded, be constantly reviewing your strategy. be considering all the different types of intellectual property and making sure that there is a strategy and that you're not just going along in the dark and working it out as you go on. Best to have a strategy and work to that. So business planning, and the reason we talk about this business planning and how it should align with an IP strategy. I read a lot of business plans. I as well as working on this Gateshead innovation program, I work on programs in North Shields, North Tyneside, Sunderland. I work on an Innovate UK project called the Digital Launchpad, the North East businesses, and I also do work for the Business Intellectual Property Centre based at Newcastle City Library. So I see a lot of business plans, and I see a lot of business plans that don't mention intellectual property. And I shouldn't. I'm happy to say I don't think I should see any business plans that don't mention intellectual property, even if it's a top level review of your position, because you're doing something, you're doing something that isn't innovative, that is not involved, it doesn't involve intellectual property as a strategy, or you're not planning to license, or you're not planning to sell intellectual property. You're just delivering a service per se, and a lot of people are delivering that service. You should still have done a sort of top line review of your intellectual property position. What do you have? Should I be trademarking my brand? Should I, as I build my brand and set myself apart from others delivering the similar services, should I be trademarking my brand? You should not look at a whole business plan that doesn't mention intellectual property in any terms. And what I've listed here is different areas of the business plan that you would want to see in a good business plan, and what elements of intellectual property you might talk about within them. So executive summary, you may not talk about intellectual property. If you are an intellectual property heavy business, you might talk about intellectual property in your exec summary. Company description and elevator pitch. You may touch upon it. You may touch upon on IP if you're pitching to someone for 2 minutes. You may talk about the protection of IP to save from the investment if you're talking to an investor. Market analysis, so your market research and your competitor analysis. You would expect to see some IP landscape in here. So someone reviewing the IP landscape around the industry that they're moving into, or the industry that they're innovating within, to go, this is what the landscape looks like. This is who else is innovating within this field. This is what they're doing. And then freedom to operate. So freedom to operate is quite an exclusive right in the intellectual property world. It's sometimes, I guess it's a term that gets used differently. So if you work with the universities and stuff, they talk a lot about freedom to operate, but they're not talking about it in the same terms as a patent attorney might talk about freedom to operate. But it's, am I doing something and am I infringing someone by doing this? And you want to be comfortable as you possibly can to say, I'm not infringing anyone, because you don't want to wake up every morning wondering if a letter's going to come to the door from someone else's solicitor saying, we think you've infringed our intellectual property. And that sort of market research and that competitor analysis. So competitor analysis and knowing what IP your competitors own, pardon. And that can also guide, should you be thinking about IP? How much should you be thinking about IP? Are your competitors IP heavy? Have they got numerous patents, a big IP portfolio? And if so, do you need to be in doing that? You can't go, because you might get, you might go in and find, well, it's already been done. They've got IP. I always use the example. I worked with a doctor who made a range of sunglasses for young, small, very small children with a particular eye condition. I don't know what the eye condition was. I'm not a doctor myself. It was a lot of years ago. But they created these sunglasses to protect children's eyes who had this specific eye condition. And the innovation consultancy that I was working for at the time, we hosted their website for them. That was a service we offered. So we developed their website with a small company and host it for them. And I turned into the office as I would, 8 a.m. every morning, sat down with the IT team, website ready to go, 9 a.m., go live. Before 9:15, Oakley Sunglasses on the phone to me. That's all our intellectual property. You need to close that down completely. That business just needs to disappear. And it did, and there wasn't much we could do, and the doctor had to move on to a different project. It was a shame, because it was doing such a good thing for these children with this eye condition. But that sort of competitor analysis and market research, had that been done in depth more, then they might not have come across that. Another situation, I worked with a different, not patents, but I worked with a company who made frozen drinks, a range of frozen drinks. They were going to get these machines to deliver these frozen drinks across shops right across the north. So machines, there was hats, there was polo shirts, there was cups, there was merchandise, all printed, all ready to go. With a big launch expected, they were going to drive around and deliver these machines and all this merchandise one morning. In 1 week a number of years ago, and a couple of days before, 48 hours before, they got a call from Costa Coffee, the IP department at Costa Coffee, and they said, we think that brand is too close to our Frappuccino brand. And the long and short of it is that involved a whole rebrand. That product never went out to the market in that format. They had to go and they had to rebrand, and they did get some recompense from Costa Coffee for doing that, but it did not cover cost of rebranding. And had they done their market research, had they done that sort of section of their business planning more thoroughly, they may not have come across that problem. They may have avoided it, and they may have saved themselves a lot of money. Okay. So marketing and sales strategy, I think we've already touched upon. So your marketing strategy and your trademark, your branding, that all ties in with each other. So as I say, the value in the trademark, the value in a good trademark is a good branding strategy. So once the branding strategy is built and the brand is believed in, there's massive value in the trademark. You may well feel at the early stage when you're filing your trademark, but no one knows what your brand is. You struggle to see that value in why you're protecting it and what you're doing. And that's perfectly understandable. But as the brand grows and people begin to trust the brand trust, the belief in the brand, you want all your trademarks there because you don't want someone coming along with something similar and taking customers off you because people think that their business is your business. And that's the big worry that people have, that you lose sales because someone buys a different product or a different service that looks similar because they thought it was you. So do it early on. Do come and talk to me about trademarking strategy. Do come and talk to me about filing trademarks. It's worth doing in the early stages and not leaving till later. But I understand, and believe me, I understand that it's a struggle to see that value early on. So that stuff we'll talk about. How are you going to get that return on investment? It's not a level of patents. It's in the hundreds of pounds for trademarking rather than the thousands of pounds. But you need to foresee what value you're going to get from it, and that's around the line it with your marketing and your branding strategy, and then your sales strategy. So IP licensing. We're going to talk about licensing in the second part of the session today. We will take a break at around probably 10:55, but we're going to talk about IP licensing later on. Historically, a lot of programs, the projects I worked on, were funded by something called European Regional Development Funding while we were still in the European Union. And we worked with clients with the view that we kind of coached them as if they were going to they were going to be their own commercial vehicle and take their own product to market. We're a bit wiser nowadays. I think we work with people and we ask them about what their strategy is. How far are you going to go to the market, and when might you have to license or sell your intellectual property and move on to the next project? And I looked at the attendee list this morning. I know there's a couple of people in the room who are from quite IP heavy businesses and have a really good solid strategy in doing this. So it's good to see people doing that, and happy to work with people who go, I aren't the commercial vehicle. I aren't going to set up the manufacturing plant. I aren't going to sell a product into the National Health Service, into the housing consortiums. I'm going to be the person who protects the intellectual property, sells or licenses out the intellectual property, moves on to my next innovation. And that's a perfectly good person to be. It's fantastic for the Northeast. There's nothing wrong with us licensing out to London companies, licensing out to big international companies. It's a perfectly conceivable business growth or route to market method. So, all the different ways of routes to market there are, we tend to work with people to make sure that they've got the one that suits them and something that they can deliver on. I often see it as like a meter stick. You've got a meter stick and you go, I can probably get us this far, but I still need to get here. And actually, maybe I need to get someone else to do that. Maybe it goes to someone else and then goes to someone else again to get it right to the market. And in that, you can kind of get a visual. If you take a meter stick, you kind of get a visual of how much you put in, therefore how much you expect to get out. So people get quite shocked. So when you're licensing, I did a lot of license negotiations in my time and worked with companies to license their IP and the negotiations involved in that. If you've never done that before, you kind of walk in and quite often you go, this is probably a 50-50 split. Should we take 50% each? In reality, you're protecting some intellectual property. Certainly in the National Health Service, in healthcare and medtech, there's still clinical trialing to go through. There's design for manufacturers, various things to go through, and really you're not putting 50% in by protecting the intellectual property, and you have to be realistic about that. But having that meter stick in mind and go, how far have I gone along the meter stick, and how far do I need to go to get to the end, gives you an idea of what value you've put in, and therefore what value you would get out if you were licensing your intellectual property. Obviously, in your business plan, you've got a management and organizational structure, description of products and services, and IP protection again. So in there, if you're talking about your products and services in your business plan, which ultimately, if you've got a business plan without talking about your products and services, then again, it's probably not the best business plan. It needs reworking. But what IP protection have you got on them products and services, or what IP protection do you intend to have on them products and services? You can't be penalised for not doing everything on day one, but you need a review. If you go and speak to someone, if you get a sort of, we talk about talking to investors, and people go, I've spoken to an investor and I got feedback and they sent me away to do X, Y, and Z. You've been sent away. There's maybe things that if you'd have got prepared 100% before you went in the first time, you wouldn't have been sent away to do more things. You would have gone, they would have gone, everything's there. I'm happy to explore investing in this business. I'm happy to explore investing in your innovation. And that's the best position to be in. So you can't be penalised for not doing everything on day one, but having a review and a plan in place. That's why business plans exist. To say we're reviewing it, we're assessing it, we've probably got into a pattern at this stage or whatever, is good to have in there. Your operating plan and your IP strategy, they should come hand in hand. Your IP strategy should sit seamlessly in your operating plan if you are an IP heavy business. Financial forecasting and needs. So yes, we're talking about, some people do bootstrap and some people fund their business from day one right to products to market. I'm not saying they don't. What I'm saying, I've worked in the Northeast region for a long time. We at UMI do a lot of work to bring investment to the region. If you're innovating, you may well need investment. Financial forecasting and needs and IP valuation around that is absolutely essential. So various IP valuation tools out there, complex tools that do a lot of, a lot of them have AI involvement and utilize AI to give you a value on your intellectual property. In simple terms, I've, worked with lots of companies who do it fantastically. Like I say, lots of different complex methods to valuing IP. In simple terms, you want to know what your intellectual property has with regards to potential for you exploiting a market. I would always use an example of a client I worked with who had a patent, and they'd used an IP valuation tool that had come out with a figure of 1.5 million for the value of their patent. They then subsequently contacted a lot of high-end stores, your Sainsbury's, Marks and Spencer's, Phoenix, Waitrose, such forth, just with an email saying, I've got something you'll want and I'll sell you it for 1.5 million. On top of that, I can't tell you what it is because I'm protecting my intellectual property. And after sending these emails out and not getting any response from many companies, they came to me and they said, Wayne, why this has been valued at 1.5 million? Why haven't anyone bought it off me? Well, for the obvious reasons that I'm talking about it now, there's obviously various reasons why it wasn't purchased off him. But largely with regards to IP valuation, it's about the IP valuation is telling you how much of the market the IP can be exploited through the IP. So 1.5 million is sort of like a top level. If someone purchased it outright off you for 1.5 million, they would spend their whole time exploiting it just to break even. So I think understanding that, so IP valuation, fantastic tool, especially in financial forecasting and needs evaluation in business planning. IP valuation is important if you're at that stage. That said, use it carefully. Don't assume that because you've got a value in something, you can just go off and sell it for that price. That's not how it works. So it's a useful tool. In the wrong hands or misunderstood, it's next to useless. So and being informed on that is really important. Proposed exit strategy. So all good business plans, you would expect to see an exit strategy. How are we going to move on from this business and move on to the next innovation? an IP transfer and what would happen with intellectual property in that happening is really important. So if you look at this page, you talk about your business plan, all these different elements. You might see other elements in business plans, by the way. These are fundamentals, but there's other things that are great to see as well. But you're looking at each one and areas of intellectual property that you should be addressing within each of these sections, and you can see why your intellectual property strategy should be tied in with your business planning. And that's why it's important, just that slide there. So we'll move on from it though. Okay. We will take a break in 10 minutes. I'll talk briefly about non-disclosure agreements. We might take a break and come back into it. So non-disclosure agreements or confidentiality agreements, NDAs, CDAs, not something I'm not fussy about the name on the front of a document. Legal documents are all about what the document does, what the clauses within it do and what they say and what they dictate rather than what it's called. So people will go, I always say it's about collaborate. People go, oh, you've got a collaboration agreement. Well, you need a partnership agreement. Well, you've just read the front page. You haven't read what the clauses are within the agreement and how they dictate how business happens. So I think that's more important than what's on the front. But NDAs, often not called NDAs, non-disclosure agreements, or CDAs, confidentiality disclosure agreements, should be pretty similar things. I think this is a great bit of advice first, is the best way to keep something confidential is to not disclose it in the first place. So as you innovate and as you do work to develop your innovation and develop your business around it, and you're talking to people in the early stages, constantly reviewing, asking yourself, do I need to talk to someone about this? Do I need to mention this? Do I need to tell someone, disclose to someone information that is commercially viable and that has commercial value to me? Do I need to disclose it? And if the answer is no, then don't. It's often not a simple yes or no. It's risk against reward. So yes, you might go, oh well, there's a potential customer here, and I need to reel them in. So I might need to share, because they're industry experts. I might need to share a bit more than just telling them what it is. I might need to tell them about how it works. But it's risk against reward. So considering each conversation you have. But if you don't need to tell someone, don't tell them. If you do need to tell them, use a confidentiality agreement or a non-disclosure agreement to protect that conversation. The kind of people I'm talking about, you might be speaking to investors, you might be speaking to manufacturers, stockists, potential customers. You may also have to tell people about a business or idea to get advice from accountants, from banks, business consultants, or professional services, IP attorneys and such forth. Confidentiality agreements standing alone. Someone once said to me, they said, Wayne, I've got a drawer full of these, and they're just in a drawer and they don't do anything. I don't do anything with them. And I pick them up and I don't know what they're about. Like, I don't know when I had that conversation or what have you. My best advice is to use them, but add context, either within the agreement or to an email. So you might, let's say for a quick example, you might be meeting with a client, or you might be meeting with a potential customer, and you need to tell them details about the product or the innovation, and you want them to sign a confidentiality agreement. Prior to the meeting, you want to send them the confidentiality agreement in an email and say, I'm sending you a confidentiality agreement to protect the conversations that we're going to be having in this meeting on this date at this time, where we'll be loosely discussing or broadly discussing these topics. And that means, and then if you go away and file your confidentiality agreement after it's signed, file it away with a copy of the email. So when you see it, you go, oh, the email relates to that confidentiality agreement, and it adds to your protection. It's an extra layer. It's belt and braces stuff. Or otherwise, you have all these confidentiality agreements. They all look exactly the same, and they're all signed by different people on different dates. And you go, I wouldn't know. And that doesn't really add much value. So you can see why adding the context is important. But again, any support around confidentiality agreements, using them, it's stuff I can help with. So do come and talk to me. We'll go a bit deeper. So I always say, if you're presented with an NDA or a CDA, the title, the header on the front page of the document is absolutely relevant. It is the content and the context of the clauses that matters. So I've already talked about that. I can't stress that enough. Don't dwell on what it says on the front of a document, whatever the document's called, CDA, and someone go, what's the difference between a CDA and NDA? Well, it's the legal clauses within a document that are important. It could conceivably say collaboration agreement on the front, and then within it, the clauses could be a confidentiality agreement. So it's about the clauses. It's not about going, that's a confidentiality agreement. I need to sign one. They've asked me to sign one. That is one because it says it on the front. So I'm just going to sign it. You really need to be looking at the clauses and making sure you can adhere to them. I've always looked at confidentiality agreements presented to the businesses I've worked for in the past 12 years to make sure they're okay to be signed on our part, to make sure that we can meet the clauses within the agreement, that the person who's presented to us, who presented the agreement, we can meet them clauses. On an occasion that didn't happen, and I guess I would always say that the biggest issue is, the historic problem is, normally comes around disposal of information. So confidentiality agreements have been around for years. You can get templates off the internet. And back in the 90s, back in the 2000s even, disposal of information was pretty straightforward. You took some information in a file. If you were asked to dispose of it, you stuck it in the paper shredder and off it went. In 2025, you can't dispose of information that easily. And if you've adhered to a clause saying you will dispose of information rather than will make the best efforts to dispose of information, on this occasion, someone had signed up to a clause to say that they would pay someone external to come and remove information from their computer systems. And they went, surely we'd have to pay for this. I said, well, you did sign an agreement saying that if this was requested, we will pay for it. And actually, that's why you should have looked at the clauses in the agreement. So rather than what's on the front, looking at the clauses in the agreement. This is my own opinion. I'm not saying that this is fact, but if an NDA or a confidentiality agreement is more than 2 sides long, I think it's probably too long. It probably means you're getting involved in something more complex than what this is used for. This is to protect an initial discussion. So it should really be for an exploratory discussion into a particular project, going, I've got this. Is this something you're interested in collaborating on? Something you might be interested in buying? Something you might be interested in working as a third-party developer on? And this is protected to the confidentiality agreement was signed. If you're signing something more long and robust, it isn't a confidentiality agreement. It is moving into collaboration agreements, and it's presuming that you've already accepted that you're going to do further work on something. So you shouldn't be doing that. You should be using your confidentiality agreement to go and disclose, share information with someone, and then going away. And both parties should then absorb that information to decide whether they want to do the thing that they went to discuss. And if they don't, that's the end of the relationship. If they do, they should work on a new agreement, a collaboration agreement, a partnership agreement, a sales agreement, whatever it is. But what I don't like to hear, but again, do hear it often, someone will go to me, they go, I've been working with so-and-so for 3 years. I go, okay, what's the agreement to, can I look at the agreement that you've got with them to deliver this project so I can see where you are on track? And they go, oh, we're doing it under NDA. And I go, well, I can't look at an NDA, a confidentiality agreement, to decide whether you're on track doing this. That's not how it works. I can't, it's just not, you can't do it. You're not protected to carry on doing that. Once you've decided to go into a relationship, a business relationship with another business, B2B, B2C, whatever, that needs a more robust agreement. And that's when the NDA finishes and something new starts. An NDA or confidentiality agreement for a potential customer would rarely be the same as one for a potential collaborator. Ensure documents are fit for purpose. So as I say, ensure that everyone involved can adhere to the clauses within them and that they make sense. If you're selling someone something, or if you're buying something off someone, they're completely different relationships. So make sure that the agreement you have with them makes sense for what you're going to be doing with them. Ensure you can adhere to all clauses within the document. Already touched upon that. And that NDAs or CDAs protect the initial disclosure of background intellectual property. So 2 parties, 2-way NDA confidentiality agreement, they're both bringing background intellectual property to a potential collaboration, let's say. They both bring background intellectual property and they're coming to disclose this, okay? And that's your background intellectual property. That's not going to move, okay? It's going to remain background intellectual property. If they then get together to work on a collaboration project, the stuff developed within that project will become foreground intellectual property, and how that's designated and who owns that will be decided within the collaboration agreement which they undertake. So this is really covering loosely, there's always variance in things, but this is loosely covering background intellectual property, and foreground intellectual property will be covered within the agreement. So if it's okay with everyone, I'm going to take a quick break, 10 minutes. So I'll make it 10:55 and come back at 11:05. Do feel free in that time to drop anything into the live Q&A And then if there's anything when we come back from break, we can deal with that. And then we'll just crack on for the second part of the presentation at 11:05. So thank you for all for bearing with so far, and I'll see you all in 10 minutes. Hello, welcome back, everybody. I hope everybody's got themselves a nice hot drink or a glass of water, whatever you need. So, yeah, second part of the session. I will just quickly deal with. We've got a question from Peter that I'll quickly deal with. So, Peter asking to be pointed in direction of some example text for employment contracts and work hire contracts that can use the jump off point. I'm happy to share something offline and have a chat with you about that. I think what's important is understanding, does it say what it needs to say? So with regards to employment contracts, you're looking at saying all intellectual property created within your role at company X, all intellectual property automatically belongs to the person, the employer. And you know that moves it, so it's got legal movement. It's got clause that legally moves the intellectual property from one place to another. With regards to third-party contracts, you're looking ideally for a two-way transactional clause, so to say. Upon payment of the project, money goes one way. All intellectual property created within the project will revert to the person who paid for the project. I always use the example of when I was. And I don't know why I use this example. It's probably embarrassing on my part. But when I was a kid, you would now and again, you would see a house or a property for sale for £1, and I would shout at my parents for not wanting to buy the intellectual property to buy the property for £1 because it's £1. It seems like a bargain. Later in life, I realised that the property was never worth £1. It was a money pit, so to speak. But it's got transaction of money moving one way and property moving the other way. And intellectual property works in exactly the same way. So the sort of type transaction is that the money goes one way, you pay for the project, intellectual property goes the other way. But absolutely happy to have a discussion about what them clauses can look like specifically with regards to wording. So I think we've completed on that page, but I think we've got a bit more about NDA, so we'll just crack on with that. So this is about details of what we'd expect to see in a non-disclosure agreement. So details of involved parties, normally the disclosing party and the receiving party, but there may be other parties involved in the discussions. Definitions, so that's any contract you would expect to see definitions. These are definitions of certain terms used in a document for the purposes of the document, i.e. what does the effective date mean? What does confidential information mean? It's what do these terms mean in terms of this document, in the context of this document that we're reading right now. Details of how the confidential information can or cannot be used. I would say in a consultancy world where I deliver consultancy to clients, quite often funded by local government, by Innovate UK, the government's innovation arm, historically funded by European Regional Development Funding. You might get a client say to me, Wayne, I need you to sign a confidentiality agreement saying you will not share any information with anyone. And I would have to go back and say, there might be information within your business that I have to share with my funders. It won't be the intellectual property, it won't be, but I can't sign a document so that I will not tell anyone anything about us working together, because I might have to for tell the government who I'm working with. I might share that information with them. So in that instance, I would normally, if a client came to me and presented me with a confidentiality agreement, I would come back to them with what I call a confidentiality engagement letter, where I developed it with solicitors over a number of years in relation to these types of projects that we deliver on. And it's specific to this type of business consultancy funded project to say, we're not going to do X, Y, and Z with it, which you don't want us to do, but we may have to do A, B, and C with it to appease our funders and to share information that we need to share. And being clear and explicit about that is what's really important. Details of who it can or cannot be shared with. So what can I share, what can't I share, who can I share it with, who can't I share it with. Again, we touched on this before the break, but disposal of confidential information. Important clause, make sure it's realistic and make sure it's, the term reasonable efforts is often quite a well-used one to say, look, we've tried to dispose the information as best we can. We've made conceivable efforts. That said, we can't remove it from our IT systems. We can't take it out of the cloud or whatever. I'm not techie, but you can imagine the difficulties. Duration and jurisdiction. So it's nice to see a duration of how long the confidentiality agreement stands for. You normally look to see a duration between 2 and 5 years, but then you want something outlining how long they're going to review the information for as well. So you might have that. We talked about that initial meeting. You go, look, I'm coming to meet you to discuss this potential opportunity to work together, collaborate, partnership, custom B2C, B2B, whatever it is. We're going to discuss that. And then we might go away and absorb this information for 3 months and then get together again to decide whether to proceed to whatever the amount of time is, 30 days or whatever. You can be explicit about that. That doesn't need to be the duration on the confidentiality agreement. You normally see something between 2 and 5 years. And jurisdiction. So which set of laws are you working under? Are you working under UK law, or are you negotiating with someone in a different country and are you working under their laws as well? You need to know what jurisdiction you're working under, because that's what laws it apply to it, or it applies to. So really important: duration, jurisdiction, and then signed, countersigned, and dated. So if you don't get that back signed prior to the meeting with the client and you disclose all that confidential information, you're disclosing that at risk. People often do subsequently sign confidentiality agreements and backdate them. That's not best practice. We don't advise that. We want you to have the agreements in place and ready to go before these meetings happen and before this confidential information moves from one party to the other. It's just best practice, belt and braces stuff. Okay. How long am I protected? I think we've touched upon this already. An NDA and CDA is intended to protect the initial discussions, sharing of information with a view to making a decision as to whether the involved parties will engage in further business under whatever terms that is, whether I say it could be B2C, could be with relation to investment or mergers or acquisitions, investment round, third-party developers, designers, consultants, etc. Any ongoing relationship between the involved parties. This could be through collaboration, using collaboration agreements or memorandums of understanding, partnership agreements, all the things that we've touched upon. But this protects that initial discussion. And once you come out of that initial discussion and decide to proceed with a working relationship with someone, you want something more robust in place. You don't want to be saying 2 years down the line that you've developed a project under NDA without a more robust agreement to ensure, when I'm talking about and what I'm talking about, I talk about a collaboration agreement. I'm talking about responsibilities, delegation of finances, timescales, all this stuff that would not go into a confidentiality agreement, but ensures that a project goes in the right direction and progresses. And quite often when projects stall, collaboration projects, and when they stall, it's because that collaboration agreement isn't robust and isn't in place. Therefore, no one knows what they're doing or what they're meant to be doing. No one has any timescales to adhere to. Therefore, other projects they have with other people that have more robust agreements take priority because the agreement's there and they have to adhere to it. I don't want to dwell on that. I just want to, understand that confidentiality agreement, NDA, initial discussions. Yes, we're going to proceed. New agreement. No, we're not going to proceed. Disposal of information. Okay. So proving the concept whilst retaining your IP, MVPs, and working prototypes. So we're talking about how you retain your IP in the innovation process. So at this stage, you will likely start to put larger sums of money into your project and not just time. In the business planning stage, in the market research and all that we talked about previously, you might spend some money on market research. You might spend some money on external people, but ultimately, when you start building the MVP or building the working prototype, this is where you start spending money on the project. It's not just time. I can't stress enough that when you're using these people, when you're using third-party developers or design agencies or whatever, them agreeing to work with you and build what you're asking for is not validation that you have something that's commercially viable. It's really important. The amount of people who go, well, of course this is commercially viable. It was designed by this person. You go, well, that there's a lot of work prior to getting this designed by a designer or built by a third-party developer. They're not responsible for its commercial viability. They're making money themselves. That's their business. They aren't going to be the person who carries it to market. So you need to make sure it's commercially viable yourself. If you do use third parties in this process, ensure that all intellectual property created reverts back to your business. Simply paying for a service does not mean that you own the IP created. So going, well, I paid for it, of course I own it. No, that's not the way. You want to see in the agreement saying, well, we've discussed this and that, but relates to Peter's question. Money moves one way, intellectual property moves the other. It lies with my business and I paid for it and everyone's happy. Use NDAs and CDAs, regularly review your position. asking, is there something we can protect? Is there something we need to change in our IP strategy? Your IP strategy isn't we've done an IP strategy and let's move on. It's just as a business plan or a business growth strategy is a moving beast. You're constantly reviewing, you're constantly pivoting, you're constantly changing, adapting, whatever. Pardon, IP strategy exactly the same. So you want to be going, especially in early stage of a project, you go, look, we've done a review. There's nothing we can protect right now, but we're going to go through the next stage of the process, and then we will reassess and we will see if there's something we can protect at that point, something that adds value to our IP portfolio, ultimately adding value to our business. Okay. Financial forecasting and needs. So another part of your business plan that I didn't mention earlier, but I just want to sit on its own. So any potential stakeholder, investor, grant administrator will expect to see at least 2 years of future forecasts with solid justification that you're able to deliver against them. Writing IP costs written into any forecast or needs proposal shows forethought in strategy and adds credibility to your innovation journey. So addressing in the different areas of the business plan that we talked about earlier, addressing the different areas of IP, it shows that you've got credibility, it shows that you know what you're doing, it shows that you've got more chance of succeeding in your innovation journey, making you more investable, making you more likely to be able to levy investment or other monies, Innovate UK monies or whatever it is. Important to remember that financial forecasting and financial projections are not the same thing. Financial projections are based on previous evidence of financial activity. Financial forecasts are just that, they're like the weather forecast. This is an IP session, so I'm not dwelling on this. I meet a lot of clients who don't do financial forecasting because it scares them, and I know why it scares them, but it is what it is, and it needs to be done. And it needs to be done, especially if you're developing a sort of IP-heavy business with a deep IP strategy. You need to know how you're going to pay for it. Therefore, financial forecasting and financial needs are absolutely instrumental in you delivering on the IP strategy that you've created. Okay. So, as part of another project that we run a couple of access to finance programs, one in the Tees Valley, one in the north of Tyne area that does cover Gateshead. So our access to finance program is linked to what we call our Northern Investor Hub. Our Northern Investor Hub is a consortium of investors who we work with to bring investment to the Northeast. The way there's many ways of de-risking investment, and that's what investors are looking at. The reason historically people haven't invested in the region is because they see it as too much of a risk. So we look at ways of de-risking it. Okay, Innovate UK might supplement investments with their own monies, with Innovate UK monies. We've got projects that do things like that, but ultimately we help our investors de-risk by using our innovation readiness level, our investment readiness levels. So these are our investment readiness levels, 1 to 9. Number 8, legal and IP management. So making sure that a company has addressed their legal and IP management before they start asking for investment, before they start looking for investment, is absolutely essential. Ultimately, once you've got to the end of all these levels, once you've done 1, 2, 3, 4, 5, 6, 7, 8, and 9, you are ready to stand in front of investors and start pitching for investment and start asking for money. If you haven't done one of them, then you're not ready, and it's likely that investor will turn around and go, well, where's your financial projections? Where's your legal and IP strategy? Where's your business model development? Where's your market traction? Where are you going to get that from? Where, any of them, they could pick out any of them. So we work with clients to make sure that they've ticked all these off. Therefore, we're comfortable introducing them to our consortium of investing and all the Investor Hub. The reason I talk about it is obviously because legal and IP management is in there. You can't get around this if you want to levy outside investment for your innovation. It's a perfect way of proving that you are innovating using IP, but you can't get around it. You can't just skip it. You can't skip any of them levels. I like legal and IP management best because it's my bread and butter, but every single one of them levels is important in taking the product to market successfully and de-risking any potential investment that someone might want to put into your business. Okay. I think the final section, I'm sorry, I didn't realize that the second part was going to be so short, but we'll crack on. Is trading with your intellectual property. So different types of trading with your intellectual property. It's an intangible asset. You can trade with it as you wish. You can do what you can give your intellectual property away if you want. I won't touch upon that here, but absolutely you are in rights to assign your intellectual property to someone else free of charge if you wish to do so. So selling. So if you don't want to or cannot exploit your intellectual property yourself, you can sell it to someone else. This means that you get paid for the IP you've spent time and money developing. The buyer is then often free to exploit intellectual property in whatever way they choose. Again, that's a perfect route. It's a perfect business growth strategy, or a perfectly conceivable route. I won't say route to market strategy, but it's your individual route to market strategy. So your market is selling your intellectual property. You might be someone who, and again, I know there's a couple of clients in the room who do this, who create IP, license it out or sell it out, and then move on to the next project. And that might be how your business runs. It might be it's a perfectly conceivable way of doing business. Selling means you're selling the rights completely. You're making a sale. You value in terms of the fact that you're selling it completely. You're not getting royalty payments. You're not reviewing 5-year projects or 10-year licenses. You're selling and you're letting go. You're not buying that back unless someone offers to sell you it back. You're really cutting loose and moving on to the next innovation project. Licensing. A license is an agreement between you as the IP right owner and another party. It grants them permission to do something that will be an infringement of the rights without the license. So if the license wasn't in place, they would be infringing your rights if they did what would be in the license. IP can be licensed out or licensed in. You can license out to another company in return for a fee or royalty, or you can license in if you want to use another company's IP to develop your own business and product. So it goes both ways. The person granting a license is usually called a licensor, and the person receiving the license is called a licensee. There may be more than one licensor, there may be more than one licensee in a license agreement. Licensing it can get complex. I don't want it to scare people. I know there's clients in the room who are going through these processes at the moment. It shouldn't scare people. It's very flexible licensing. So people go, quite often go, can I do this? Can I do that? Absolutely. If the clauses within the agreement say that's what it does, that there isn't really limitations. I always use the example, and this wasn't a good example, by the way. This was a lot of years ago. Worked with a NHS trust who developed some children's toys, chewable toys for children with learning disabilities, and their accounts team decided that it would be easier for them to manage a license if they took £1 for every unit sold rather than a percentage. And I said, Wayne, can we take £1 for every £1 British pound for every unit sold rather than a percentage, because it makes it easier for our accounts team to manage the license? Absolutely. Doesn't make sense, because we know that £1 now, that was probably signed 7-8 years ago, that license, and it was probably a 10-year license. That £1 per item now will not stick the same as a £1 per item did, cost of living crisis. You don't get much for £1 nowadays compared to what you got for £1 8 years ago. So yes, you can do these things. There are standard things you tend to see in a license agreement. So you would always advise, if someone asks to do it, you understand the risks of doing that. And I will have outlined them 8 years ago. I would have said the risk of doing that is that the world completely changes and the pound becomes worth a lot less. And they went, no, we want to do it this way. They might have re-agreed that license. I'm not involved in the project anymore. Okay, good. I'll move on to the next page. Sorry, there we go, I've lost my mouse. So, trading with your IP. Licensing your IP can allow you control over an array of factors, such as exclusivity. So you can exclusively license your IP to someone and go, you are the only person who could use this IP in this geographical area, territory. So you might go, you can, you're the only person who can develop this IP and trade with this IP in China, and you're giving someone exclusivity in China. But you can then go and give someone else exclusivity in India and someone else exclusivity in France, provided you've protected the intellectual property in these countries. You can break that down into areas within the United Kingdom if you want to. You can go, I'm giving you, territory to trade within the Northeast, but I might give exclusivity to someone else in London, or I might give you the whole UK, the UK to deal with. So exclusivity, and that comes at a cost. So if someone says to you, start negotiating your license, you've got your intellectual property portfolio, you go, I'm going to license you my intellectual property portfolio, and they say, I want exclusivity. I don't want you licensing this to anyone else. Once I have it, I want an exclusive license. You go, well, that comes with a cost. If I can license it to 10 people, I don't need to charge as much for it. If I can only license it to one person and then they've got control of it, and the cost goes up. So, there's a lot of complex math in relation to your business planning and your financial forecasting that become involved. It's not as simple as what is a piece of IP worth. It's not as simple as say, I get 2% because I've got a trademark, I get 5% because I've got a patent, and then I get 1% for my design, so I take 8% royalty. It's not that simple. There's so many factors. So again, exclusivity in relation to territory, in relation to industries, so markets in which the IP could be used. You go, yes, you can use this technology in the education tech market, but I don't want you sub-licensing this into the health and medtech market. So you can control these things within your license. Purposes in which the IP can be used, I say, education, commercial exploitation. So that's how the IP can be used. The reason I talk about education, publication is a good example. So universities will do a lot of research and they'll do a lot of work to retain intellectual property. Often they want to use intellectual property for publication, but aren't able to commercially exploit it. So they might have agreements where they go, we retain it for use with education and publication, and we like to publish our intellectual property and talk about it, but you can be the people who commercially exploit it. And we will talk to you if we want to publish something, we will talk to you to make sure it's signed off and that it doesn't infringe any of your rights and it doesn't damage your commercial venture in any way. I.e., we don't tell someone something that's commercially sensitive to you and you lose money because of it. And that can all be in there within a license agreement. Format of payments, for example, royalties, upfront payments, performance-related payments. All these things are possible. You've really got to think about your business is what have I put in and what do I want to get out and what do I need to get out to cover my costs, get my return on investment, and make money on top that is in line with the business growth strategy that I've set out for myself. So again, really tying into your business plan, your IP and licensing strategy, and making sure it delivers what it does in your business plan. Timescales. How long do I want to license this intellectual property for? Do I want to test the water and license it to these people exclusively for 2 years? But if they're not making their performance, that I've set them some performance things, some performance payments. If they're not making them, do I want to pull the license in 2 years and look for another licensee? There's all these things to consider. Do I want to go for 10 years? You want to be constantly reviewing that. One of the biggest things that goes amiss in any license agreements is you will have a clause in there saying we'll sit down and review this as a strategic team every 6 months, and that ends up not happening. It just ends up going by the wayside. It should not go by the wayside. It should be in there. It's in there for a reason. You should be sat down with the stakeholders every 6 months to go, how are we doing? What can we change? Do we need to change anything? How can we make sure it carries on working? Rights to future developments. Tech world, very complex. Innovation world, very complex. Naturally, when someone has your intellectual property, they might get feedback on it from their users. They might get feedback from their people who do the design work, and they might go, we've made some developments, we've made some additions to your IP, we've changed it, we've improved it. Who has the rights to that? Who has the rights to them IP, them IP developments? And I guess that's a question, but it goes in a license agreement. You decide that within a license agreement. The right to assign, sub-license, or terminate the license. So all the things. The main message on this is that a license agreement is something complex. You want to engage a solicitor. You want the larger party of the two to develop the first draft. For me, that's not fact. It's my personal opinion. A larger organization should generate a first draft, something to work against, something to start negotiating with. It's not intellectual property, but it's fundamentals of negotiation. You can then go in with your, set your stall and go, I'm walking away from negotiation if I don't get X, Y, and Z. You can start green lighting things, red lighting things, rag rating things to say, I want this to happen, I want that to happen. If this happens, I'll walk away. If this happens, it can be negotiated. This is fine. All that stuff. Quite a complex process, but not to be scared of. I think it's getting it right, and you want to be able to pick up a license agreement and go. The reason the 6 monthly reviews tend not to, I've seen them not happen in these projects when there's a license agreement in place, is often because the license agreement becomes part of the background because the project's progressing and working. It's working, and this becomes an afterthought. This is not the license doesn't become the whole project. It just becomes something that you make money off as your company, and actually you probably. And I know there's people in the room who do this. They're then working on their next development, protecting their next bit of IP, and moving on from there. So, you know, it's just knowing about what the possibilities are and the complexities are. Okay. Uh, and I hope, because I think I'm coming to the end. Yes. I'm going to, I know we've done an hour and a half, so I'll give you a bit of your time back if people were committed to being here till 12. But I'm going to stay on for the next 5 or 10 minutes, answer any questions that come in. But thank you very much for attending. Thank you very much for listening. You can scan that QR code there, and that'll take you to a page where you'll be able to find out how to contact me should you have any follow-up questions. But I will sit in for the next 10 minutes and wait for any questions should they come in. But I know a lot of people in the room have had contact with me previously anyway. Do come and chat to me. Do feel to come and, if you want to bounce anything off me, have any conversations. But largely, thank you for coming and thank you for listening. Cheers.